Today we're going to talk about pour-over wills. My name's Gregory Singleton. I'm an estate planning and probate attorney who lives in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just as a reminder, if you like today's video, please feel free to hit that like and subscribe button. It really helps support the channel. Also, a couple caveats before we get going. First of all, this video is for educational purposes only. I am not giving legal advice. I am not establishing an attorney-client relationship with everyone on YouTube. Secondly, we're going to be talking about Minnesota law here. So if you live in another jurisdiction, make sure to talk to an estate planning professional in your jurisdiction before you go to do your estate plan. That said, let's talk pour-over wills. What are they? Well, Minnesota Statute 524.2-511 establishes that a will can devise property into a trust. A will can give property into a trust. Why would we do this? That's a great question. You're probably sitting there thinking, you know what, I'm going to use a revocable living trust. Why would I need a will? Because I'm going to put all my stuff into the trust. Well, a pour-over will is different than a regular will, and mainly in that it's limited. It is doing three things. It is acting as a catch-all, it is acting as a CYA, and it is acting as a guardianship designator. So let's look at catch-all first. Here's the situation. You create a revocable living trust. You put your bank accounts, your personal property, and your house into the trust. You forgot to put your investment account into the trust. Well, the pour-over will allows the personal representative, not the trustee, the personal representative, to open a probate and put the investment account assets into the trust. If the investment account's assets are greater than $75,000, it's going to have to be an informal probate. But if it's less than $75,000, they'll just use an affidavit for collection of personal property, transfer the investment account into the trust, and then you'll just follow the trust for doing the estate administration. Having a pour-over will doesn't mean you don't fund the trust. You're still trying to avoid probate. So put everything you can in the trust. This is just a catch-all in case you forgot something. The second reason that we have a pour-over will is called a CYA, or cover your assets. Let's take the situation. You create a revocable living trust and the trust fails. Either it was poorly drafted, there's a change in law, or it was challenged in court and the trust is deemed to be unenforceable. Well, if you don't have a pour-over will, at that point, you would just follow the Minnesota intestacy statutes. And you'd give money to your spouse, then kids, then heirs, etc., etc., etc. That's probably not ideal. What a pour-over will does is it'll have a provision that says, if for some reason the trust fails and is deemed to be unenforceable, I want to have the estate go through probate, but follow the exact distribution that was established in the trust. It kind of works like a mirror or a carbon copy of the trust. You're still going to go through probate, but at least how you intended to distribute your assets will be satisfied. The final reason we use a pour-over will is to designate who gets our children after we die. Minnesota Statute 524.2-202 allows guardianship to be designated by will, by a standby guardian, or by some other writing or document that is executed in the same manner as the healthcare directive. So there's our three options. Standby guardians, first, if you've watched my other videos, they are for when you are alive but incapacitated. So we don't want to use a standby guardianship after we've died. A will, yes, we're talking about a will, so we can do that. The third one is other writing. Now, one might think that you could use a trust to designate guardianship. And theoretically, if it's established the same way, I don't see why not. However, traditionally, trusts are exclusively used for distributing assets, and kids are not assets. They are kids. So in that case, we use the pour-over will. The other reason we'll use a pour-over will to establish guardianship instead of the trust is to establish guardianship, you have to go through a court procedure. That means you have to put the document into the public record. If you put your pour-over will, that's fine. You're putting your pour-over will. It doesn't really say much. But if you have to put your trust in the public record, then everyone can see the content of the trust. One of the major reasons people use revocable living trust is to protect their privacy. Remember, when you probate a will, it becomes a public document and anyone can see it. So because we have to go through a court proceeding, we put the guardianship designation in the pour over will and rely on that. So that's my take on pour over wills. They basically work just like a will and do one thing or three things. They dump assets into the trust that you forgot to put in there. They cover your tail in case the trust fails, and they establish guardianship. I hope you liked today's video. If you did like today's video, please feel free to hit that like and subscribe button. If you do like this video and the content that I'm putting out, we do a new video every other Wednesday, so stay tuned for that. If you have any questions, put them in the comments below or send me an email, probably preferable that way, and I will certainly get back to you. Otherwise, until next time, this is Gregory Singleton with Signature Law.